Welcome to the Professional Edge. My name is Sean Todd, tax attorney, CPA, and certified financial planner, host on the Professional Edge. And what we're talking about is the 411 on probate avoidance. So we concluded last session about Romeo and who's going to get the 401k. Now, we got to understand that IRA or 401k, the largest financial asset that most couples have, is controlled by a simple beneficiary designation, a one-page document that has one line, who the primary beneficiary is, and a second line which says the contingent beneficiaries. Now, that is going to avoid the probate court process because the beneficiary designation supersedes the change of title and therefore does not pass through the probate estate. That's number one, so we avoid probate. But going back to our example, husband and wife are married. Primary beneficiary is the surviving spouse. Remainder to the kids in equal shares. So we have $1 million IRA. The participant is there. The wife will stay at home. She's the primary beneficiary. So husband passes away. We do a spousal rollover, and now wife has it. She's not in her required beginning period, so no RMDs have been paid. So we're okay there. No tax consequence. Continue on down the road. Matches what the wills are that the attorney drafted. The I love you will, which says I give everything to my surviving spouse. The remainder of beneficiaries are going to be our children in equal shares. Well, mom is on down the road a couple of years in our scenario, and she meets Romeo. Well, Romeo and her finally get married, and Romeo convinces the wife to go over to his stockbroker. He's magical, or she's magical. So guess what? The wife transfers her IRA over to the new stockbroker, and by default, the stockbroker says, well, who do you want being the beneficiary? And Romeo's sitting right there, and the stockbroker is going to say, well, if something happens to you, Romeo can roll this over and it's going to be a non-taxable event. And therefore, we're going to keep the tax deferral going. And the wife just looks at Romeo, still love in her eyes. And she signs the document, putting Romeo first, kids contingent. Now, she still has her original will, which says it goes to my spouse, but now the spouse has passed away. And it now defaults down to the children as contingent beneficiaries. Perfect. So wife unfortunately passes away. Now Romeo goes to his stockbroker with the death certificate of wife and says, I got to do that spousal rollover. Let's go ahead and roll over that $1 million IRA into my account and go from there. Well, the kids meet with the lawyer, the family lawyer that's been their lawyer for, now 20 plus years. And they say, well, mom's passed away. It's time to probate the will. And the attorney looks at it and gets a death certificate and probates the will and gets the letters testamentary. And they say, okay, when mom and dad were in here, they had you draft their documents and everything goes to surviving spouse. Got that. That's fine. Dad passed away first. Mom got everything. And now the kids are looking for mom's stuff to split equally. And they said, dad worked 30 years at the company. He had about $1 million in his IRA. And mom really didn't really touch that when she was alive. And she only left 2 years, and she never even touched it, or she touched it just a little bit, for required minimum distributions, not that much. Should be $1 million in the IRA. And the attorney goes, okay, where's the statement on that? And they said, well, it's at the new stockbroker. Okay, great. Let's get that statement. Let's contact that company and let's make a claim on that because, we're going to have to go through by beneficiary. That's what the attorney says. And then it's not controlled by the will. So let's reach out to the brokerage firm. So they do that. And then lo and behold, the brokerage firm identifies, we have the account for mom here. And let us just send over the beneficiary designation that she has made. And actually, somebody's already made a claim on that. And that was Romeo. Well, they call Romeo and say, hey, that was mom's account and that was that was dad's money, our dad's money, and that was supposed to go to us when she passed away. Well, Romeo really didn't take a liking to his wife's children, his stepchildren, and Romeo says, well, she wanted me to have it, and therefore the beneficiary designation is to me, and I have the $1 million, and it's not subject to the terms and conditions of the last will and testament. It supersedes that, and therefore I think I'm going to keep it, and you guys can have the other stuff that your mom had that she wanted you to have. Wow. Okay, so let's step back and say, whose fault is this? Well, is it the attorney's fault that drafted the last will and testament to begin with? Well, if he's doing his job, should have checked the beneficiary designations and said, okay, primary can be spouse, contingent kids, that's all good and well, as long as there's not a new spouse or a new change in beneficiary ownership. So is it the attorney's job to continue to monitor and make sure that that beneficiary is coordinated? Well, if you have annual updates on this or annual meetings to review the estate, it probably would have been caught. Kids don't get involved with parent stuff. I don't know why. So next thing, they say, okay, stockbroker, is it his fault? Stockbroker says, hey, I'm not a licensed attorney. I don't have to plan the estate. I asked a simple question. Who do you want to be the primary beneficiary? And your mom said, Romeo. I put it down. Here's her signature. I didn't write Romeo's name. She wrote Romeo's name, but she still made you guys as contingent beneficiaries. If this was something for estate planning, you should have called your estate planning attorney. So you see the finger pointing, and this happens more times than you can imagine. And if this is something you want to have a very candid conversation on to guarantee that your kids are going to receive your inherited IRA or your IRA upon your passing, and they will inherit it after the surviving spouse, give our office a call at 404-250-9798. That number again, 404-250-9798. So let's fix it. How are we going to fix this to make sure that we don't disinherit our own kids on that IRA, the largest financial asset that most families have? Here's what we're going to do. We're going to name a trust as being the primary beneficiary on that IRA. And you say, okay, I've never heard of that. Well, being a tax attorney as a CPA, not many people have, and here's why. It's just simple for the brokerage firm to put a one line and put a name in there. Well, that's ridiculous. You're controlling $1 million asset with a simple one-line beneficiary designation. Let's stop doing that. Let's designate a trust, a designated beneficiary trust, to be the primary beneficiary on that IRA. Here's what happens. Dad passes away. We look to the DBT. The DBT says mom's the primary beneficiary as long as mom shall live. Perfect. Not a problem. No tax consequence on that. Now, when mom passes away, her will can say all to new Romeo. She cannot update the beneficiary on that IRA that dad had to Romeo. She can transfer that account, but she cannot update that beneficiary designation as the DBT because dad controlled it from the grave. Yes, that's okay in my book because we want to guarantee that the household that sacrificed to get the $1 million in that IRA actually benefits from it. So mom moves over that IRA, the custodian can change, but the DBT controls the ultimate distribution. So Romeo cannot be named as a primary beneficiary for when mom passes. So the DBT says, keep mom as the primary beneficiary, meaning the owner now, for the time of her life. But when she passes away, guess what? Any remaining balance goes to the kids of the first marriage in equal shares. Romeo can put his fist on the table and say, I need to be named as the primary beneficiary. And wife can just look at him and say, I don't control it. My husband set this up. This was our agreement. He wanted to guarantee our children received any balance left. So therefore, Romeo doesn't get anything of this family IRA. Now, if that is of importance to you, write down this number, 404-250-9798. That number again, 404-250-9798. We can also schedule a Zoom call. We can meet down here in Columbus, or we can meet up in Atlanta if you want to test your driving skills. It's that important. I hope you can understand the passion that I have in my voice, because I've seen families just get messed up by not properly planning the beneficiary designation on their largest financial asset, their 401k or their IRA. They got their will done. That's all great, but they're missing the big planning point of protecting that asset. Now, they've avoided probate? Yes, absolutely 100%. Did they protect the asset? Absolutely not. That's the value of working with a tax attorney, CPA, certified financial planner. That's me, Sean Todd, tax attorney, CPA, certified financial planner. Take advantage of the opportunity that we have put together for our listeners here on the Professional Edge. That is EMC, Echo Mary Charlie, thebundle.com. It's a great value to take advantage of. And it's, yes, an impetus to get your planning done, your estate plan done properly, to guarantee that your children are going to inherit the largest financial asset, to make sure your life insurance has the right beneficiary. We're going to take a look at your taxes, and then we're also going to look at your portfolio to make sure you're holding the right investments in the right account, and whether it makes financial sense, tax sense, to make a Roth conversion. There it is, folks. Thanks for listening to the Professional Edge on the 411 Probate Avoidance. Again, you can listen to us on any podcast. It's called The Professional Edge. And if this is of value to you and you thought it was pretty incredible on the points that we're trying to make, do share it with your other colleagues. Just give them a link to The Professional Edge. Let them listen in. And thanks again.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.